we are recording the session, just to let you know, and we're planning to have some time for questions at the end, and do feel free to put your questions in the Q&A and we'll look out for those as we go. Any more housekeeping points, James?
No, I don't think, Isabel. I think we'll get going, and as Isabel says, actually, yeah, please do feed your questions in as we go. There should be some time at the end as well for some questioning. But Isabel, should we get to it?
Yes. So we're seeing the life sciences industry generally adopting AI-related technologies in a much bigger way at the moment. And on this slide, we've got some of the areas where we're seeing activity and hearing about activity, and it's really ramping up, we're finding. And we've been advising clients both on the legal and regulatory frameworks that are coming through, and also on how to craft collaboration agreements in this area, so that they'll work effectively for these kinds of collaborations. We're seeing loads of work happening around medical devices, drug development, drug plus digital, lots of exciting new areas. And although many industry participants are building their own in-house capacity, the different skill sets required when you work in AI and machine learning means that it's often makes sense to partner with specialists. And so that's the context for this session. Just turning now to the agenda, James, if you want to look at that.
Yeah, so what we did, what we don't plan to do is to go through absolutely every single issue on a collaboration agreement. What we're going to do instead is sort of to pick out those key issues that we're seeing time and time again. I mean, as Isabel says, we are seeing a lot more collaboration, out-licensing activity very much in this space when we're advising our life sciences clients. This session, as we say, is to pick out some of those key issues. We're very happy to dive into other issues. If people want to talk about other issues, we can do that. But in terms of framing this session, we thought it was probably best use of time just to sort of pick out those regular and common issues and themes that we are seeing. So Isabel, should we get to the first session? Not in any order of priority either, but hopefully quite a nice flow. Isabel.
Yeah, so the first area that we've picked out, because it will tend to arise towards the beginning of a project, the scoping. You know, how are you going to set your framework for the collaboration? So James, what considerations do we need to take into account right at the outset when we're scoping the project?
Well, I think the main point to make here, Isabel, is really to understand purpose, and purpose is absolutely crucial here, because that will then define your IP approach, your contracting approach in the context of the collaboration. So some of those questions to ask, I mean, is what we are creating here going to be a core asset for the future? So Isabel mentioned sort of drug and digital, where you are going to be the sponsor taking that forward. So clearly a core asset. Or is it the case that the AI provider will simply be using their AI, their systems, their platform to deliver services to you? So sort of different aspects there. But understanding purpose is going to be absolutely key. And really understanding how will the AI technology be used. I think one of the challenges we have with any AI collaboration is predictability of outputs. You're not going to have a really good idea of what is going to be created. We'll look at some of the tricks of the trade to deal with that, but getting real sense as to how the AI is going to be used. Will it become embedded within the product, so such as a medical device going forward? So thinking around those kinds of issues and getting a sense of that is absolutely key. And then also thinking about the contractual structure And most of the collaborations that we're advising on, we are talking about a contractual venture. So a research collaboration, in-licensing, out-licensing transaction. Although we are starting to see more complex structures in terms of creating new entities in which sort of combined technology IP sets can be can sit. But as I say, sort of commonly, it's going to be some kind of contractual venture. But thinking around structure early on is going to be important.
Yeah, we'll come on later to thinking about the sometimes you're going to need a more ongoing relationship between the parties, and in those kind of situations it might be more appropriate to have the establishment of a new entity or formal JV rather than simply a licensing arrangement. So turning now to the second theme that we've identified. Now, I think this comes up in a different way in these kind of partnerships, rather than where you have two life sciences entities working together. When you've got a tech partner, we're seeing some other cultural inputs coming along, I think. James, is that right?
Yeah, I mean, it's really to do with the style of working and developing. The tech space, very fluid, very fast moving, and obviously, but it's getting the balance right. It's clearly within the life sciences sector. We need to get some oversight. We need to really be able to understand and validate outputs, particularly as we move through to regulatory approval. So it's getting the balance right. And obviously within a traditional life sciences collaboration, we may have joint steering groups, etc. But then the lead time for the development is going to be as well quite a bit longer in practice. In relation to these kinds of collaborations, it's far more fast moving, far more fluid. So some of those questions around actually, is it going to be straight co-development, working very closely with a partner, thinking around those different work streams. How do we intend to work, and then working out actually how we reflect that within the agreement to give us the oversight and control we need. And we'll come back to some of these themes a bit later on.
So our next point is around the due diligence. Again, this is at a fairly early stage of the relationship. And due diligence comes up on every new collaboration. But what are the considerations when you're entering into a relationship with an AI development partner?
Well, you're going to be considering very similar issues. I mean, if you're considering a research collaboration with another life sciences organizations, you are going to be asking the same sorts of questions around IP ownership, dependence on in-licenses of IP, other contractual restrictions in place with third parties. So you're going to ask the same sort of questions, but with an AI collaboration, you do have some specific overlay because the IP mix is going to be very different. It's not classically going to be just a set of patents. There will be a lot of soft IP, and that's why we've mentioned on the slide the importance of soft IP in the context of know-how. There may be, or there likely to be, some embedded algorithms here. Can't commonly obtain patent protection around algorithms. So you're going to be looking at a mix of copyright, database rights, trade secrets. Obviously a bit more nebulous, and what you will get back will be a bit of a mixed bag, which will need to be distilled and thinking through. I think the other issue, I think Isabel mentioned this to me in the context of a collaboration that she's working on in relation to open source, and asking questions around that, because inevitably you're talking about technology that is software enabled. So asking questions around is there any open source here, and if so, the basis upon which it is in license, because clearly that could impact future development, future commercialization. The other issue we've got here, which we'll come to, is the challenges around almost predicting outcomes as well, and some of the thoughts around protection within the contracts. So similar sort of questions to be asked, but a specific overlay when we're talking about AI collaborations.
Yeah, so thinking a bit more around ownership and protection of IP, we would like to just highlight here that this is a really fast-moving picture. So some of the areas that are currently evolving are particularly around patents. We're seeing a lot of movement around how you can patent where there's AI technology involved. The life sciences industry as a whole tends to rely very heavily on patent protection, and that's pretty stable and well understood. But there is a new level of uncertainty. So particularly around who actually made an invention. And there's a series of litigation and patent prosecution activity at the moment around a DARBA system, which you may have come across. And it's being put forward really as a sort of project to see the limits of AI inventorship in the patent system. And there's mostly, it's received a lot of knockbacks with this AI system not being recognised as a patent inventor, and difficulties with registration of those patents. Although there have been some patents issued, for example, in South Africa, where there isn't really a formal system of scrutiny as there is elsewhere. And Australian courts have been much more willing to recognise AI inventorship. So that's a bit of a moving target there. And likewise around software, although software is normally protected through copyright, the way that it deals with AI systems can be different between different countries. And again, there's this problem around if an AI is the creator of a particular copyright work, how is that recognized? So just want to identify that there is a lot moving in this area, and there's international projects through the World Intellectual Property Organization, and to try and get a sort of joint direction going, as yet not really successful, and countries are rather going in their own ways. And the UK IPO is running a huge series of consultations to try and build a straightforward and clear framework around this area. And James mentioned some of the problems around databases. I mean, protection of databases, it is not straightforward. There is a database right in the EU and the UK, but that's not entirely watertight. And so developers do tend to turn to trade secret protection if they have key database assets. And that brings in the need for encryption and security and non-disclosure arrangements to maintain that protection. So just to highlight some of the things that are happening around IP in this area. So James, perhaps you want to comment on how that works then in relation to drafting agreements.
No, absolutely, Isabel. And I mentioned that fluidity in terms of the sort of the style of co-development in the context of these kinds of collaborations, and it's going to be similar from an IP perspective. And I always quite often talk about, well, actually, how do we mitigate risk here, so we're not having to keep on going back to the AI provider in the future and ask for further license rights, access to IP. So thinking around actually sort of how we future-proof the IP provisions, but also other aspects which we will come to. So absolutely all important. I mean, the way that we would structure the IP provisions around any collaboration arrangement going to be similar kind of construct to a more traditional life sciences collaboration. So the distinction between your background IP and your foreground IP. I suppose it is, however, thinking around how background IP is defined here from the AI provider's perspective, because what they will say quite often is, well, actually, there's the pre-existing stuff that we know, but just in terms of how our technology works, we won't necessarily know what improvements would be made to our platform. So they would want to broaden the definition of background IP to include improvements to their base platform. Clearly, those improvements are driven; they arise from the collaborations. You may have a vested interest in those improvements. So, thinking around the licensing, do you want to own those? I mean, the value of those is obviously pretty limited because clearly you're not going to own the base platform. So you may be happy with that, provided that you've got broad license rights, but also thinking about things like confidentiality, trade secret protection. Clearly, what you don't want the AI provider to do is to use all of the knowledge that they have secured through doing the collaboration with you and to take it to other partners. So being absolutely razor sharp around confidentiality and actually thinking around some of the mitigation measures you can apply here. In relation to the foreground IP, again, similar sort of constructs. I mean, the issue we've got here quite often is predicting what those outputs are going to look like. So defining that fairly generally. I mean, if we're talking here about the development of a product whereby the AI provider is using its platform technology to develop that, constructing IP provisions around ownership of all of the IP relating to the product, but giving more flexibility to the AI provider in terms of refreshes to its platform, but obviously with some of the protections that we have already spoken about. So dividing product versus process. I know in terms of a number of my clients on the call, we often have those discussions in terms of those kinds of constructs. Do also think around the drafting though, because quite often with collaboration agreements, it may be by reference to human creation, and we haven't got human creation with a lot of this here. So think around the terminology, moving away from IP generated by personnel, that kind of wording, to maybe look at IP generated for use of technology or similar in that regard. So clearly thinking around those kinds of issues and how that tracks into the wording is absolutely key. Isabel, should we move to the
let's move on
slide
to
and think about regulatory, because clearly that is going to impact quite significantly on the collaboration as well.
Yes, I mean, as with any life sciences project, you have to keep in mind the regulatory issues, and we would normally start with the basic framework that's relevant. So you tend to have the basic divide between medicines and medical devices, which obviously is important here. And all of those rules around development, getting your product to market, post-marketing follow-up and promotion, they may all be relevant here as with other life sciences collaborations. And there's particular scrutiny at the moment around things like AI in the context of medical devices. So the new EU medical devices regime brings in stricter controls in relation to software medical devices and in vitro diagnostics, with additional external assurance and life cycle management, for example. And all of those will be important if you have an AI-related medical device. And the International Medical Devices Forum has got a particular focus on AI and how it is being applied in that context, with issues around things like continuous learning and reliability being particularly significant. And then again, for medical devices, the FDA has got a working project on AI-related software as a medical device, with a focus on predetermined change control plans in pre-market submission. So if the device is placed on the market and then evolves through the normal use of AI and machine learning. You know, how do you manage that subsequently with the product as it is on the market and in operation? So we're also seeing wider regulatory initiatives around AI generally, not specific to a life sciences context, but obviously relevant. And again, the EU has a big project in hand to roll out AI regulation across all sectors. That focuses on higher risk projects in particular, but it may well be relevant where AI is being used in any kind of life sciences or healthcare project. And those products and services that are deemed high risk would be subject to a new conformity assessment process under that regime, with lower risk products having to meet transparency obligations. The UK is also adopting an initiative to shape global technical standards for AI with an increasing reliance on external assurance providers envisaged for AI products and services generally. Where AI uses data, in particular health-related data, then that is subject to increasing and stringent oversight. So there's the normal rules around privacy that you'll be familiar with. So individual personal data privacy, where individuals' data is being processed, and that's particularly acute in relation to health-related data. And we're seeing, for example, NHS projects to consider how health-related data can be used and accessed, and the deployment of that is particularly sensitive. So we're also seeing the ABPI, for example, consulting on a set of principles where health-related data is being deployed and used through the life science industry. So we've got those more sector-specific projects where health-related data is being applied, and then some more general projects around AI generally. And all of those structures, you need to identify which ones are relevant and how they will impact on the project in hand. So particularly, there may be a need for ongoing support and an ongoing relationship between the pharma or medical device developer and the AI partner. And looking to the future, there may need to be ongoing support built into your project. James, did you have anything else to add?
Yeah, just a couple points on that, Isabel. I think we're going to look at regulatory change and changes to law and practice later on, and actually how we future-proof some of that. I think there is a bit about scoping up front and understanding the regulatory pathway for a product that is going to be developed. And as Isabel says, actually there may be a mix of different regulation, because if you've got drug plus digital, companion diagnostic, you may be looking both at medicines and medical device regulations and how that impacts, but then thinking about how that then tracks through the agreement. I mean, you may, for example, have various sort of milestones within the agreement. You may agree to pay royalties to the AI provider dependent on achieving particular milestones. And so understanding that regulatory pathway clearly will allow you then to frame those sorts of provisions.
So turning now to contract governance, you've touched on before how there are cultural differences in these kinds of relationships. Perhaps we could look at how this is likely to operate when you're drafting your AI collaboration agreement.
Yeah, no, absolutely. I suppose, I mean, traditionally with life sciences collaborations, we may have joint steering committees and joint development committees, and so having quite a structured and tiered contract governance structure around these kinds of collaborations. Those may just simply not work when collaborating with a tech provider, given the, as I said, rapidity and fluidity, I think, is what I've previously mentioned around this. But clearly, what we are going to need to be completely focused on, and this also coalesces with a number of issues around, for example, IP. The delivery up of enough information that we need to be able to further validate outputs, and clearly then taking those through regulatory pathways and through to regulatory approval. So clearly we are going to need clear obligations in terms of delivery up of data and materials to be able to assess, think about, validate a lot of what has been created around this, and all these issues start to coalesce in terms of delivery up versus IP. And so thinking around that contract governance structure is going to be pretty key when we talk about actually how are you going to engage, how are you going to co-develop, and developing something that probably is going to be a bit more bespoke. It will be driven also by the tech providers' wants and needs. We're starting to see a number of different constructs in this area. We can go in and talk about some of those in a bit more detail if people would like us to do that. But contract governance is key, but actually thinking about that in a broader sense in terms of deliverables and delivery obligations on the AI provider.
So looking now at the liability issues, I mean, these are always important in a new collaboration and need to be carefully crafted. And where the differences when you have an AI technology involved are worth noting. So you could have a situation, for example, where you have an AI-supported diagnostic tool that fails to identify a cancerous lesion and a patient is left untreated. You know, if you've got the involvement of the system, the medical device creator, and even a clinician involved, you know, is finding where that responsibility lies. So you can get some particularly tricky issues arising with these technologies. You tend to have a complex interacting system with several different partners involved. And also there can be a sort of black box element where it's not quite clear exactly how the thought process has as it were, has operated in the system and not entirely transparent. And you can have bias and inaccuracy that creeps in through the nature of the databases used. So there can be some specific liability concerns in these kinds of relationships. James, what are your thoughts on how we might address those kind of issues in the agreement?
Well, the tech provider is going to want to have caps on liability. I mean, I think what we are very much sort of seeing in this space is agreeing an appropriate limitation on liability for the tech provider. That may be a multiple of contract value, but then maybe dealing with some of those bigger risk areas through things like super caps. So. And this is sort of how we're seeing some of these collaborations and approaches to collaborations develop. So you strip out some of these key risk areas and agree super caps with a tech provider. That may be around issues like IP infringement, confidentiality is going to be absolutely key. Possibly regulatory breaches. This is going to be an area where the tech provider is going to be concerned, because if we're talking about the development of a product for you, they're very much going to lose control after the front end development. You may have ongoing commitments on them in terms of tech assistance, know-how assistance, which we'll come to in a bit. But clearly they are going to be concerned about picking up liability for third-party claims further down the line, where they'll say, well, actually, we've got no control over how they are managed. So I think we're moving away from your classic, well, actually, this is the limitation of liability, to something more tiered in approach, and using sort of super caps on liability to address key risk areas. One of the other key risk areas, which actually we mentioned on the slide, is around cyber security. It may be that the AI provider will be hosting a ton of data sets for you, and clearly we would expect them to comply with all appropriate rules and laws around the application of those kinds of technologies. And clearly within the pharma space, we will have our own industry codes, etc., that we would expect them to adhere to. So maybe thinking about a more nuanced position in relation to liability, and it's all about seeking some kind of balance here in order to address both parties' concerns, because at the end of the day, it is a collaboration. Isabel.
Yeah. So then moving towards later stages, we all hope the collaboration will go to plan, but it's worth considering that there may be a need to bring things to an end. There could be a misaligned expectations, for example, or a failure of the program in some way. So James, how might we deal with those kind of issues in an agreement?
Well, I think it's thinking around the termination rights for us first of all. And classically, we'll have the unremedied material breach, insolvency, etc. termination rights. But often the failure is a bit more nuanced than that. It's just not delivering as expected, but no real breach there, but it's not simply working. I mean, clearly within a classic life sciences collaboration, we would have as sponsor ability to terminate for convenience, and clearly that needs to be a right built into the collaboration agreement. I mean, that should be one way. You don't want the AI provider sort of walking away sort of midway through the co-development, and you can give them some comfort there in terms of paying for their costs, committed costs, etc. So you should be able to seek a mutual position that works for both parties in that regard. The other area that we are seeing is around things like change of control as well. Because they may be holding a load of your data, hosting a load of data, ongoing commitments in terms of service provision, you may want to have some kind of check and balance over an acquisition by a third party who may not necessarily have the same interest going forward, or you may just feel will not have the capacity. There could be some sort of competitor type issues as well. So thinking around those kinds of termination rights as well. So getting the termination rights is going to be absolutely key. I suppose the other issue in terms of pharma will be around sort of safety concerns as well. So some of those more sort of standard termination rights that you would expect in the context of a research collaboration. But then it's thinking about the consequences of termination as well. So no impact on IP licenses, so the ability to be able to continue to use, and also thinking about those ongoing obligations. The product's got so far, you would envisage that actually there would be additional things in terms of development, but it's gone so far. You've got a product you want to develop and take to clinical market, and there may be a need for those ongoing obligations to remain in place because of that ongoing dependence that you will have on the tech provider in terms of delivery up of support and data and assistance. So think about termination unwinding in relation to those two specific areas.
Yes, you've talked a bit about the need for continuing technical support, and we've mentioned that earlier and how important it may be. So perhaps we could talk a little bit more about those issues.
Yeah, so I mean, this is all about continue, and I suppose the difference between this sort of collaboration and more classic life sciences collaboration is that with many of these interactions, you may need ongoing support and assistance, the ability to be able to access data, technology, ongoing know-how, technical assistance, but also thinking around, well, actually, what happens if the area provider doesn't provide insolvency? So also thinking around escrow arrangements, so the ability to be able to access the technology if the AI provider is no longer there, or just simply failing to deliver. Do you want delivery up of source code as well? It will depend on the nature of the collaboration, but actually thinking about some of these issues early on is going to be absolutely key, because of the inherent need to be able to continue to rely upon support from the AI provider, and particularly as you then move through to regulatory approval and the like.
So then our final point is around the changes to law and practice. We've mentioned throughout some of these developments that are currently underway. It's a fast-moving theme, and it's worth considering how you might cover off some of those risks in the agreement.
Yeah, and this is always quite a difficult area. I mean, we know that further regulation is coming down the line, and obviously we're also a global industry as well. So there's the dynamic of different regulations. We hope that there will be harmonisation around law and regulations in this space, but it will take time, and then take time to sort of bed down. So we know that changes are around the corner, and so actually how do we deal with that in the context of the agreement, future-proofing the arrangement, having the flexibility around all of this to accommodate. So who bears the risk in terms of regulatory change and the cost in relation to that? And what we've seen in this space is almost a division of labour and risk in this regard. So clearly, if you've got the tech provider who is going to be hosting data, so you've got all the issues around privacy, cyber security in relation to their own use. You want them to continue to commit to meet regulatory changes as and when they arise. You may also want a structure whereby these sorts of issues are there is a forum for discussing these areas, these issues, such that they can then be addressed through contract variations and the like. But clearly, you're going to want to have some base protection around this to be absolutely clear in terms of what the tech provider is accepting going forward in terms of changes to law and practice. You will also have your own policies as well. So in terms of refresher policies around things like information security, in relation to data use, as and when you refresh those, you're probably going to want to have flexibility within the agreement to pass those through to the provider. So it's thinking around, again, a lot of those issues early on. I think, Isabel, we've come to the end of of going through all the various slides, and I think we've got time now for questions.